that protected the rights of workers and of the vulnerable by guaranteeing minimum wages and providing limits on maximum hours and protecting the interests of women workers and child workers and so on. A group of very conservative, politically conservative justices on the Supreme Court held these laws unconstitutional. In an era of activism, they walked away from the deferential approach that their predecessors had taken, and they invalidated almost all of these laws on the ground that they violated what they decided was the constitutional liberty of contract. Even though this was nowhere explicitly in the Constitution, they concluded that individuals and businesses have a constitutional right to make contracts freely. And if they can manipulate people who are powerless to accept jobs on terms that are objectively unfair and discriminatory, that's the liberty of contract. And that is a right they should be understood to have. And therefore, this very conservative Supreme Court, in what was known as the Lochner Era, named after a court case named Lochner, invalidated most of the progressive legislation. In that era, it was liberals who advocated an approach of deference by the courts. The courts shouldn't be invalidating these laws. Their argument was that it is appropriate to give the democratic branches of government the authority to make these decisions, and nothing in the Constitution authorizes the judiciary to hold them unconstitutional. So during this era, at the late 19th, early 20th centuries, it was political conservatives who were what we would call activists, adopting an aggressive understanding of the Constitution, even though there was not even any explicit guarantee of liberty of contract. And it was liberals and progressives who advocated a passive view, a judicial restraint view of constitutional interpretation. Now, the problem with that approach, from the standpoint of progressives, is that it would constrain conservative justices from imposing their own personal values on the nation in the guise of constitutional interpretation, but would also fail to serve what Madison and Jefferson and what the framers of our Constitution expected courts to do, which was to protect the rights of our citizens. In 1938, as the court moved away from this Lochner era, Chief Justice Harlan Fiske Stone, no relation I should say to me, wrote a famous footnote in a case called Caroline Products. Footnote 4 in Caroline Products, Chief Justice Stone basically said the following. He said the appropriate stance for the judiciary is one of deference. We should not second guess the democratically elected branches of government. We should not impose what we think to be good policy on the nation if it is inconsistent with the views of the majority. However, he said, there are circumstances where the majority cannot be trusted. There are circumstances in which they will act in ways that are inconsistent with the fundamental values and guarantees and rights of our Constitution. And they will do this out of their own self-interest. And that is the nature of mankind. And echoing Madison and Jefferson, what he suggested in his famous footnote 4 is that there are two situations in which it is essentially imperative for the judiciary not to be passive, not to be restrained, but in fact to be active in guaranteeing and protecting those rights that are guaranteed in the Constitution and not deferring to the majority. Those two circumstances he identified were first, when the majority is acting in a way that clearly disadvantages the other. That is, those members of our community who they regard as different from themselves, as individuals whose rights they don't care about, and where they act in a way which may be perfectly natural for human nature, but which is fundamentally incompatible with the aspirations of a democracy. And in that circumstance, he said, it is essential that courts step in and act to protect our democracy against that kind of indifference or hostility. And what he was thinking about, of course, were groups like African Americans and others, people accused of crime, women, and the like. Second, footnote 4 suggested that the other circumstance in which judges should be not passive in interpreting and applying the Constitution are situations in which democracy itself is imperiled. Human nature being what it is, the majority, given the power to make the rules, will inevitably make rules that protect and preserve their own power. They will make rules about the electoral process, about the voting process, that ensure that they will continue to be the majority in government. And that, too, is incompatible with the core values and purposes of our Constitution. And it is where, again, courts must step in, because one cannot trust the majority to restrain itself in these circumstances, as history clearly demonstrates. So in footnote 4 in Caroline Products, Chief Justice Stone suggested that those are the two circumstances when the court, in giving content to the guarantees of the Constitution, should not be restrained, should not be passive, but should be more aggressive in giving meaning to the constitutional provisions to address these two fundamental malfunctions of democracy: hostility or indifference to the other, and efforts to ensure that one's own political power stays intact. Now, the Warren Court was the perfect exemplar of a court that sought to fulfill the vision of footnote 4. I'll give some examples of that. To begin with, there was, of course, the Supreme Court's decision in Brown versus Board of Education in 1954. In the late 19th century, the Supreme Court upheld the principle of separate but equal, of racial segregation, in which African Americans had to sit at the back of the bus, had to sit in separate train cars, had to go to separate schools, and so on. In Brown v. Board of Education in 1954, the Supreme Court revisited that question. Now, when the court first heard arguments in Brown v. Board of Education, in the spring of 1954, the justices were divided on the question. Chief Justice Vinson was one of the strongest proponents of reaffirming Plessy v. Ferguson and upholding the constitutionality of racial segregation. That summer, the court decided not to decide Brown, but to put it off for a while, because they understood how complicated and how fundamental it was as an issue of American constitutional law, and to rehear the case the following fall. That summer, Chief Justice Vinson died. Felix Frankfurter, who was generally conservative, famously said, "This is the first time I've ever believed there was a God." President Eisenhower, a Republican and no great liberal, appointed Earl Warren to replace Chief Justice Vinson. Warren was not known to be a liberal. He had been the governor of California. He had played an unfortunate and active role in the Japanese internment during World War II, and was generally regarded as a fairly conservative governor. When he arrived at the Supreme Court, and the court met again to deliberate on Brown, Warren took the lead in the arguments within the court and essentially made the point that in our society it is essential, given the provision of the 14th Amendment, that no state shall deny to any person the equal protection of the laws. The laws that aggressively discriminate on the basis of race cannot be constitutional, for the obvious reason that the people in the government who passed these laws would never have passed these laws to disadvantage themselves. These were clearly examples of majorities acting in ways that were indifferent to the harm they were causing to other groups in society. And that this is a situation where the court has to step in and enforce the constitutional guarantees and aspirations of the country against that kind of failing of democracy. And the court in Brown, in a unanimous 9-0 decision, held, of course, that separate but equal was a violation of the Equal Protection Clause. It was a highly controversial and divisive decision that led to violent responses in the South, but it today remains one of the truly great decisions of the Supreme Court of the United States. So when I said that the Warren Court exemplified this footnote 4 notion about the central and primary responsibility of the judiciary in interpreting and applying the Constitution was to protect against these two inappropriate actions by majorities, the Warren Court exemplified that. Another example is the decision in a case called the Engel versus Vitale, in which the Warren Court held that school prayer was a violation of the Establishment Clause of the First Amendment. It recognized that for school districts to require students to recite the Lord's Prayer before every day, at the opening of every school day, was to clearly and dramatically disadvantage those children who did not hold that faith. They were required either to actually recite the Lord's Prayer, or, in some school districts at least, were allowed to leave the room if they wished to do so, in a situation that obviously caused not only embarrassment, but pain to these students. And the Warren Court held that this was indifferent to the interests of those who do not share the religious views of the majority, particularly children, and was incompatible with the aspirations of the First Amendment, which prohibits any law respecting the establishment of religion. In a series of other decisions, the Warren Court protected the rights of individuals who were accused of crime and who themselves had no political power in the democratic process. Individuals who are accused of crime are not realistically going to have any influence on the legislative process in a city or a state or in the government. So, for example, the Warren Court held that individuals who are arrested have a right to the assistance of counsel, even if they cannot afford one. They held that if the police engage in unconstitutional searches of individuals, that the evidence obtained in those searches cannot be used against them in a criminal prosecution, because otherwise they would be utterly without any meaningful rights under the Fourth Amendment. They held that when individuals are arrested, they have a right to Miranda warnings, to be warned that they have a right to counsel, that they have a right not to respond to the police. And again, this was an effort to create a fairer, more just criminal justice system. Another decision the Warren Court reached was in the case of Loving versus Virginia, which in 1967 held that laws prohibiting intermarriage between blacks and whites, were unconstitutional and discriminatory. They also held, directly relevant to the League of Women Voters, in Reynolds v. Sims, that states had to follow the principle of one person, one vote. Initially, historically, states had more or less equal population in their legislative electoral districts, whether for the state legislature or for the Congress. But over time, what happened throughout most states in the country is individuals moved from rural areas to urban areas. And what happened then is that the number of people living in electoral districts, instead of being more or less equal throughout the state, became dramatically warped. And a rural district tended to have 1/10 as many residents as an urban district, or 1/20th as an urban district. And the state legislatures would not change it because they were controlled by the rural districts. And the rural districts were not about to take away their own overrepresentation in order to create a fair and equal electoral process. And so the Supreme Court, in Reynolds v. Sims, held that districts have to be established on the principle of one person, one vote. Because if the court did not intervene, the states wouldn't do anything about it, because those who controlled the majority of districts in the legislature were not about to vote to take away their own power. So only the courts could have stepped in and addressed that inequality and that dysfunction in the democratic system. So the Warren Court, in my view, is the model of what a judicial body should do in interpreting the Constitution. Being assertive in those two types of situations that were noted in footnote 4. When a majority is acting in a way that is unfair to minorities, where the minorities have no realistic power to protect themselves in the democratic process, and to protect the democratic process from abuse by those who have majoritarian control at any given time. Now, in the half century since the Warren Court ended, since Earl Warren retired and several other justices on the Warren Court retired, the Supreme Court has changed profoundly in its understanding of its role in interpreting and applying the Constitution. Most of the decisions of the Warren Court that were most important were perceived as liberal decisions and were upsetting to political conservatives, who were generally the losers as a result of these outcomes. In the years since the Warren Court ended, Republican presidents have appointed 14 of the 18 justices who've been appointed to the Supreme Court. This is, in fact, not because Republican candidates have won the presidential election anything like 14 of 18 times, but it's because, in part, of manipulation of the nomination and confirmation process, that they have managed, even though winning only roughly half the elections, to appoint 14 of the 18 justices since 1969. Now, the question then is what those justices would understand to be their appropriate approach to interpreting the Constitution. They did not embrace footnote 4. They did not embrace the Warren Court's approach. But the question is, what approach would they take to the question of interpretation? One approach they might have taken is to go back to the idea of judicial restraint. And there were some early Republican appointees, like people like Harry Blackmun and Lewis Powell and Warren Burger, who basically believed in judicial restraint. That is, they thought the Warren Court went too far, they were not going to replicate that, and they were going to be much more passive in their interpretation and application of the right to freedom of speech and press, the right to be free from unreasonable searches and seizures, the right to equal protection of the laws. A second group of these judges came up with the idea of originalism. In particular, Robert Bork and Antonin Scalia, who at the time was my colleague on the faculty at the University of Chicago, came up with the idea of originalism as a way of interpreting the Constitution. Their argument was that judges should not have the flexibility to interpret the Constitution the way the Warren Court did. They should be much more constrained and much more respectful to the judgments of the majority. But they shouldn't completely abdicate responsibility. They should apply the Constitution to invalidate laws only if those laws were clearly intended by the framers of any particular constitution to be unconstitutional. And the idea was to basically ask, what was the original intention, the original understanding of the framers of these guarantees? What did the framers mean by freedom of speech or of the press, or by equal protection of the laws, or by due process of law, or search and seizure, and so on? And the job of a judge, their position was to simply put yourself in the position of the framers from 200 years ago or 150 years ago, ask what they intended when they adopted these provisions, and only those laws that they affirmatively understood to be rendered unconstitutional should be held to be unconstitutional. The idea was to constrain the discretion of judges. And now, whether this is a principled or good approach is debatable and often debated. The primary advantage of it would be to take away, in theory, the ability of justices to attribute their own values to these open-ended constitutional provisions, and to simply be reflective of what the framers themselves understood and intended. There are a number of problems with originalism, which has been largely discredited since Bork and Scalia first put it forth. One problem with it is that it's completely inconsistent with the understandings and intentions of the framers. The framers themselves understood they were drafting these provisions as very open-ended, non-precise guarantees. They guaranteed values of freedom of speech, of freedom of religion, of equal protection, of due process, of freedom from unreasonable searches and seizures. But they never even talked about what those provisions actually meant. They were talking about these being fundamental values of our Constitution. And for the most part, we don't know what they intended in these regards. And in fact, what we do know is they intended these things to be open-ended and vague, and to evolve over time as situations changed, as our values changed. What equal protection of the laws meant was not just about race. They could have said no African American shall be denied the equal protection of the laws. That was the primary focus of their concern at the time. But they didn't say that. They could have written that. Instead, they left it open-ended. And they left it open-ended intentionally, because their understanding was that these words, these values can evolve as society evolves. And it can be the case that women could be denied equal protection of the laws, which they would not have thought at the time. That was not what they were thinking about. Or even that gays and lesbians can be denied equal protection of the laws, which they certainly would not have thought about. So one of the problems with originalism is that we don't really know what they intended in any concrete sense. And second of all, what we most likely know they intended was not originalism. It was, in fact, an open-ended, reasonable evolution of these provisions as society changes. One good example of this is a search and seizure issue. When the Supreme Court initially, in the 1930s, addressed the question whether wiretapping is a search under the Fourth Amendment, the Supreme Court said, no, The framers had no position on wiretapping. Wiretapping didn't exist. There were no telephones. Therefore, we cannot hold, taking an originalist approach, we cannot hold that wiretapping is a search for which the government needs probable cause and a warrant. It was not until the Warren Court in 1967 that they held no, that the invasion of privacy in wiretapping is no different than the invasion of privacy in opening mail by the government, which the framers certainly saw as a search under the Fourth Amendment. Okay, so in the years since the Warren Court, the conservative justices have handed down a series of decisions that I would argue are incompatible with both originalism and with footnote 4 and with the aspirations of Madison and Jefferson. And I'll give you just a few examples. One obvious example is the position these justices have taken on the issue of affirmative action, holding that efforts of government entities, like public universities, for example, to achieve a higher degree of equality by taking race into account in hiring faculty and selecting students violates the Equal Protection Clause of the 14th Amendment, which was clearly designed to protect African Americans from the discrimination of whites. Now, one can make an argument that affirmative action is problematic, but it has nothing to do with originalism. The framers of the 14th Amendment would never have thought about this even as a possible reality, let alone as something that would be unconstitutional. Another example is the fact that these justices have basically held that laws regulating campaign expenditures are unconstitutional. That is, the government passing laws that say individuals cannot contribute or spend more than X amount of money in supporting particular political candidates. The purpose of those laws is, of course, to try to create a political process that is not dominated by billionaires, and that is consistent with the principle of one person, one vote. And yet this Supreme Court held in Citizens United that those laws are unconstitutional. Certainly there's nothing originalist about that, and it's antithetical to the values of footnote 4, because it gives enormous power to a small number of billionaires that completely gives them the authority to basically control what elected people, what elected representatives will do if they want more money from them in the future. Another example is these justices held last year that political gerrymandering is not unconstitutional. Political gerrymandering basically means that those in positions of power in the government, in the state legislature, draw the district lines for their own elections and for congressional elections. And what they're capable today of doing, given computers, is to define the districts in such a way so that you pack, let's assume you're Republicans in control of the state legislature, you pack the Democrats into a small number of districts by drawing the lines, and you put the Republicans in the majority, say 60%, in many more districts, even though there's an equal number of Democrats and Republicans in the state. And in a 5-4 decision, the Republican appointed justices held that doesn't violate the Constitution. That's perfectly okay, which is completely the opposite of what the Warren Court was doing in the one person, one vote era. I could go on with many similar examples. But the key point I want to make is that the Supreme Court has come to be controlled over the last half century by justices, by a majority of justices who do not share the democracy and equality understanding of constitutional law, who do not in fact act under the constraints of originalism, but who in case after case tend to decide these cases in ways, I'm sorry to say, basically empowers their political side. And that creates a real undermining of the integrity and credibility of the Supreme Court as an institution. Adding to that is we now have, for the first time in history, 5 justices appointed by one political party, in this case Republican, 4 justices appointed by the other political party, in this case Democrat, and in virtually all of the most highly ideological cases, they vote 5 Republicans, 4 Democrats. And they vote in ways that you could predict, not being lawyers, not knowing anything about constitutional law, but if one were to ask you, what do you think Republicans or Democrats prefer? Result A or result B? And in these highly ideological, highly important cases, including gun control and gerrymandering and the like, campaign finance reform, you could predict how they will vote simply by knowing what political party they're from. That's never happened before in the history of the Supreme Court. And it poses, in my view, grave questions about whether the court can retain its essential integrity to exercise the extraordinary power that it has, to have, in fact, the confidence of the people that the justices are acting in a principled, thoughtful manner, rather than as political entities acting out of the interests of their own political parties. We've never had a Supreme Court divided in that way, where the justices act in accord with the political views of the parties that appointed them before. And since I believe, and the framers believed, that having a principled Supreme Court is essential to the core of American democracy, what we're now seeing is the undermining of that state of affairs. And a classic example of it was the decision of Senator McConnell to refuse to confirm President Obama's nomination of Merrick Garland, who was completely qualified, a very thoughtful, very moderate judge, in fact, because he wanted a Republican president to get to replace Justice Scalia. And sure enough, it worked out that way. And that, again, is a situation that really has never happened before. So as someone who spends his whole career writing about and thinking about the Supreme Court, just as our democracy at the moment is in a state of dire peril, so too, I would suggest, is our Supreme Court. And on that happy note, I will stop and invite questions.
Do you have time for questions?
Sure. I'm sorry to go on so long. I care a lot about these issues. And I'm happy to take questions if you want to stick around.
Please keep your questions brief and concise, and when our guest speaker is done, he will say he's done. And we do have announcements after, so please stick around for a while afterward.
Thank you. So just raise your hand if you have a question, or I'll call on you. Yes.
Do you have any comments about the current Attorney General?
Bill Barr was the Attorney General before, under George W. Bush. At the time, he was regarded as a reasonably responsible, thoughtful Attorney General. What he has become in the years since and in the months since he has been appointed is just shocking to people. I don't know Barr personally, but I know lots of people who do, and to a person, they are shocked at who he has become. And I don't know what has caused that in him, but it is utterly shocking. The Attorney General of the United States is supposed to be, and historically has been, a nonpartisan head of our United States justice system, not the agent of the president, but willing and responsible to do what is right under our law rather than to be a political agent. And I'm aware of no Attorney General who has been as politically biased and perverse, I have to say, as Barr has been during his service. And as I said, I know lots of people who know Barr and they're shocked by it. But there's just no question, you know, looking at it objectively, that his behavior just is not only completely inconsistent with the role of an Attorney General, which is to be non-political, but also it's just completely weird and bizarre for a good lawyer. For him to suggest, as he has just the other day, that individuals who have called for protests that involved violence should be prosecuted under the Sedition Act of the United States is truly insane. For one thing, he doesn't seem to know the Sedition Act was repealed in 1920. And it is regarded as probably the single worst federal law in the history of our country. It basically, during World War I, when it was enacted, authorized the government to prosecute people who criticized the government. And that was completely antithetical to the First Amendment and to the values of a democracy. And I'm pretty confident in saying that no Attorney General of the United States since 1919 has referred to the Sedition Act in a positive way. It has been an embarrassment, a humiliation. Between 10 and 20,000 Americans were put in jail under the Espionage Act of 1917 or the Sedition Act of 1918 for criticizing the war or the draft. And they were sentenced to between 10 and 20 years in prison. And as soon as the war ended, it became apparent this was a disaster. This was a horror show. And Congress repealed the Sedition Act. And here we have the Attorney General of the United States, a century later, threatening to invoke the Sedition Act against people who are protesting against government policy. It's unimaginable, frankly. Other questions? Yes?
It bothers me that the 14th Amendment has been used something like 4 or 5 times more for justifying cases for corporations instead of human civil rights. Could you talk about that?
Could you repeat the question?
Yes. The question is, it is bothersome that the 14th Amendment, which guarantees the due process of law and equal protection of the laws against the states, has been used 4 times as often to protect corporations by the Supreme Court in recent years than individuals. I don't know if the 4-time number is accurate, but it is the case that the Constitution was not understood by the framers to guarantee the rights of corporations. It was to guarantee the rights of individuals. And the 14th Amendment provides that no person shall be denied due process of law or the equal protections of the laws or the privileges and immunities of citizenship. And this court in recent years has extended the protection of those guarantees across a range of issues to corporations in a way that never seemed particularly sensible. Citizens United, which I mentioned a few moments ago, is a good example, where the Supreme Court held that not only can the government not constitutionally restrain or limit the amount that billionaires as individuals can spend in the political process, but it cannot limit the amount corporations can spend in the political process. And its extension of the protection of free speech not only to individuals but to corporations across a range of issues is similarly unprecedented. So now I don't happen to think, I have to say, I don't happen to think that's as crazy as some of the other things I've mentioned. But I do think that applying it in the way they have, so I do think corporations have rights under the Constitution. But the notion that they have rights identical to individuals is an extreme interpretation. And frankly, much of it comes about because of the role money has played in the political process and the extent to which corporations have played a critical role in donations. And one of the reasons why the court held that the Campaign Finance Act, the Bipartisan Campaign Finance Act, which was enacted in 2002, the McCain-Feingold Act, John McCain and Russ Feingold, Republican and Democrat, that limited the amount that corporations could spend in the political process, signed into law by George W. Bush, was held unconstitutional as applied to corporations. They have, the Supreme Court said, the exact same right individuals have. So does that mean they have a right to vote? I mean, why not? Do they have a right to serve as jurors? They're not people under the 14th Amendment, but that's how this group of justices has interpreted and applied it. And it is problematic, both in the sense that it's an extension of the guarantees of these provisions that was never anticipated or understood. So originalism can't remotely justify these decisions. And one has to ask, well, if this is the way you think about corporations, do they get to vote? Right? Why not? Right? Did they get to serve as jurors? Right? That seems pretty bizarre. So too, frankly, and by the way, the recent decision of Citizens United overruled a 1931 decision of the Supreme Court that said that corporations do not have a right under the First Amendment to spend their money in the political process. So it's not even that it was a dramatic and radical decision, but it actually overruled a prior decision of the Supreme Court that was unanimous from 7 decades earlier.
Is there a scenario, or is it wishful thinking on some people's part to think that a president could negotiate for a third term?
No. That there is a constitutional amendment that clearly limits a president to 2 terms. That's unequivocal. And now, could he negotiate for that? Could a president negotiate for it? It all depends on whether the branches of the federal government are willing to enforce the Constitution. So, I mean, it wouldn't be legal. It would clearly be a violation of the specific constitutional provision that limits presidents to 2 terms. That's unambiguous. But, let's suppose that the Congress decides to appoint a president for the 3rd term, and others bring a lawsuit claiming that violates the Constitution, which it clearly does, and judges say, no, it's fine with us. Then what? That's not a happy scenario. But one of the key things is that up till now, the court has acted, at least over the last half century, in a reasonably principled way. And its decisions have been followed. Now, in the Warren Court era, there was bitter opposition to many of the Warren Court's decisions because they were highly anti-majoritarian. But over time, all of them have come to be accepted, even those that were extremely bitterly opposed. And that's in itself a really interesting phenomenon. Now, whether they'll continue to be accepted as we go forward remains to be seen. School prayer is an example where now, for the first time in almost half a century, you find school districts talking about reinstituting school prayer in public schools. And that's because our political society has changed in ways that are, for me at least, highly problematic. Okay, so thank you all very much for coming. This was a lot of fun.